Okay, thank you very much to Professor Smith. The second keynote speaker of this session is Judge Peter Boshier. Judge Boshier was appointed as the Principal Family Court Judge of the New Zealand Family Court in March 2004. He's been a District Court Judge since 1988, and throughout his time as a judge has played a significant role in contributing to improvements in how the law interacts with broader society in New Zealand and overseas. He conducted a wide-ranging review of the family court in 1983, wrote the Child Offenders Manual in 1999, and in 2002 was seconded by the New Zealand government to join the Pacific Judicial Education Program in Suva in Fiji. In April 2009, he was made a distinguished alumnus of the Victoria University of Wellington, and he was recently appointed to the Law Commission for a 5-year term. Judge Boshier has a particular interest in Pacific youth justice and child offenders, and is well known for being generous in giving his time to speak to community organisations on the family court and broader issues in the law. Judge Boshier.
Tēnā koutou katoa. Tēnā koutou e hui mai nei ko tēnei te mihi kia koutou katoa. Tēnā rawatu mō te koutou karanga mai, ki te mihi atu I te ahi nei. Well, you can see that I've entitled my talk to you this afternoon, Achieving Equity, Our Children's Right to Opportunity. So, much has been happening concerning family law and the place of children in New Zealand in recent times. This heightened focus on vulnerable children and family law is understandable, given both the reality of New Zealand's appalling rates of child abuse, neglect and poverty, and also given the huge amounts that these issues are costing the state. And the other reason I believe that family law is warranted as a predominant issue is because, frankly, it's one of the most important areas that affects New Zealanders from birth to death, right across the spectrum. Very recently, the government has described the recent family court announced reforms as, quotes, putting children first, and exhorted us to have a more child-focused approach. This followed earlier signals from the government that private family law disputes, that is, the disputes between parents concerning who should care for children, were costing too much money and were diverting attention away from cases that really matter. This meant the government, perhaps unsurprisingly, influenced by the current fiscal climate, focused on scrutinising processes for Care of Children Act cases in the family court, which make up 40% of our workload. Now, while those parents and children caught up in parental conflict may suffer stress, anxiety, and potential damage once the parental conflict is resolved, most parents in our country manage to continue to provide a level of parenting which offers their children the best possible start in life. Other parents simply are not capable of this skill. And sadly, it is the children of these parents who do not have access to the same opportunities as most New Zealand children have at the outset. If the proposed reforms of the family court do have the claimed effect of reducing some of the clog of our courts, then I hope a flow-on consequence will be that we have the ability to really concentrate on children at risk and to afford them a better life opportunity than we have historically. At present, we are not doing good enough. The Green Paper, which I'm sure have heard much about, outlines some statistics for New Zealand children, including the 21,000 confirmed cases of abuse and neglect in 2009-10, over 1,300 hospital admissions in 2008 and 9 for children and young people that could have been avoided, and the fact that more than 30,000 students are truant in school on any given day. These awful statistics should be a call for action. But the other impetus to act to make real change for these children is drawn from a moral obligation as members of a civilised society to protect and safeguard the most vulnerable members of our society. All the research points towards the inescapable position that early intervention is an absolute necessity. Certainly in the inquiry into the identification, rehabilitation and care and protection of child offenders report, a select committee report released on 20 June this year, that committee wasted no time in indicating that early intervention for children who were seen as being at risk early on simply had to occur, and that government agencies owed a duty of care to share their information much better and to ensure that they were accountable for their outcomes in relation to these children, accountable for their outcomes. After setting out the underpinning framework of children's rights, in the very short time I have, I want to explore some of the characteristics of children and young people that I believe we should be focusing on. Now, I should indicate that I'm conscious of time and I'm simply going to get as far as I can, knowing that there is a paper now on the Family Court website which you can access, which sets out the whole of my speech, and secondly, my wonderful research clerk, Julia Spellman, who's contributed so much to this paper, has run off 40 copies which are available to hand out. Now, the United Nations Covenant on the Rights of the Child. Well, we ratified this in 1993, and certainly since that time, there have been integration of this into parts of our legislation and policy. It's in many ways been a touchstone. And for a family court judge, Article 12 has been given effect to by appointing lawyers to represent children in proceedings in the family court. Why? To ensure the opportunity of the right to be heard. There is legislative direction now in the Care of Children Act to take a child's views into account. And the two statutes that are most important, the Children, Young Persons and Their Families Act and the Care of Children Act, are very clear on that. Now back to my theme. I believe that as a society, we have a collective sense that children born in New Zealand are born with the right to opportunity. Results from a longitudinal study of migrants who have been granted permanent residence in New Zealand show that top reasons for choosing New Zealand as a place to live are, and I quote, relaxed place or lifestyle, climate or the green environment, and a better future for my children. And I think we are lucky to live in a country with stable democratic government, a beautiful and life-giving environment, and one which provides many opportunities. That some children are deprived of these opportunities because of poor parenting, societal ambivalence to inequality, and unsatisfactory agency response is unacceptable, ladies and gentlemen, in a civilised society such as ours. Children do have rights, and we must hold our heads high so far as our international obligations are concerned. Now is the time for this country to be concentrating on our children at risk, and we must address the issues earlier than we have been prepared to, as children's chances in life occur so very early on. Now, children in need of care or protection. Well, in the year 2010-2011, we know that SIFs received 150,747 care and protection notifications, an increase of 20.7% from the previous year. And what's suggested is that the increase is in part due to the greater awareness of family violence, and I would go along with that. There is a significant concern about a child or young person quite often, and it's important that depending on what that concern is, child, youth and family, or the police, if it's child offending, can make an application that that child is in need of care or protection. Now these children that I'm talking about share commonalities. They are children and young people who often show a history of parental drug and alcohol abuse, family violence, neglect, offending, and economic hardship. The checklist is often the same. So for the children who come into SIF's care, gateway assessments are undertaken. And in relation to those, they show, I think, interesting results. So you'll see from this that of the assessments in the July to 2011, March 2012, that these are the needs. There they are. Emotional, 49%. Dental, not surprising, 31%. Alcohol and drug abuse, and there it is. All of these, I imagine, won't be a surprise to you. When I spoke to a Rotary group earlier this year, I referred to the Christchurch longitudinal study, which suggests that a child who is raised in a poor family faces a barrier to future educational and economic success independent of the child's academic ability and family context. That study suggests that addressing child poverty and reducing home equality will have, and I quote, far-reaching effects on the long-term well-being of children and young people. Now, the patterns that we're identifying, I want to talk about some practical steps in the time I have left. So having acknowledged that within the family court context, we may have had rather a large emphasis on what I'll call these private law cases in the past, that is, disputes between parents that were usually called custody and access disputes. I want to talk about the really vulnerable and the children in need of coordinated intervention. What steps in relation to the group that I want to have better opportunities can we take? And the three brief things I want to cover with you are these. I want to talk about information sharing. I want to talk about creating a specialist division of the family court. And I want to talk about an increased power to compel agencies to act and be accountable. So, information sharing. Well, last year, the former Ombudsman, Mel Smith, reported on a West Auckland case of shocking abuse, and in his recommendations, he referred to the lamentable lack of interagency cooperation and information sharing. His quote's a great one, but in the interests of time, I'll let you read it in the paper. So this was also a key theme that came through in the submissions on the Green Paper for vulnerable children. In 2009, I participated in what was called the Independent Experts Forum on Child Abuse. And in the recommendations we made to the Minister of Social Development, we argued that the government needed to take the necessary steps to allow for data sharing between agencies to happen as a matter of course. Now, calls for sharing and ideas such as the always open file are not new. And I acknowledge that changes around data and information sharing carry with them a duty to consider privacy impacts and the risks around stigmatizing any individuals or families. I'm conscious of this, but it should not get in the way. The longer we wait, the more children and young people are suffering in the health context. Calls for better information management really have been made repeatedly, and only last week, the Expert Advisory Group on Solutions to Child Poverty made recommendations along these lines. So I believe it's time to start implementing these ideas. Enough of the talk. I hope that the government's upcoming announcements on the results of the Green Paper will squarely and fairly address this issue. Now, a specialist division of the family court. Another recommendation in the Mel Smith report was the establishment of a separate child protection court so that specialist judges, dedicated staff, and social workers committed to this large group of children. We do about 17,000 applications for care and protection in our court each year, so that these could be better resourced and be given special commitment. The recently announced family court reforms do not propose the setting up of a separate child protection court, and I agree with that policy. However, I think there is merit in establishing a child protection division of the family court responsible for handling child offenders and the children who are in need of care or protection, and who the state has asked the family court to oversee through the making of orders and the review of plans. I think it would focus resources and ensure better management applies. Dilution of these cases amongst our total cases, which number 66,000 per year, so dilution amongst all of these would be less risky with a specialist division. I favour, in relation to these children, formulation of case management plans and a protocol which sees a clear time frame, accountability, and an audit at the end of the plan to ensure that we have actually achieved what we needed to protect the child and give that child the opportunity they deserve. Ideally, these cases will have sole judge management. Now, another thing I want to say before I move to my final point. It will be important as we reform the family court that we ensure that children are afforded the dignity of participation in their own destiny. This is something that the Care of Children Act insisted on, and it did so because of scathing criticism in the Law Commission's 2003 report that the family court was often paying perfunctory attention to children's rights and their views. I would never want us to simply be an online service in which we move through speedily from problem to conclusion without properly addressing the dignity of people, the right they have to participate and be heard, and in particular, for our very vulnerable children to feel that they matter. To stop and listen and to take account of children's views is, in my view, the true mark of a civilised society. Now, finally, power to compel agencies. I think that we should create mechanisms so that agencies can be held to account for what they should be doing. In his report, Mr. Smith recommended a compulsory conference that a judge could refer matters to when all important players, including those government departments that needed to be consulted, would be required to attend and where they would be accountable for the actions which were needed. If we learn lessons from the Mel Smith report, we know that some agencies, and health and education spring to mind, need to own the risk and the answers in just the same way as other agencies do, such as the Ministry of Social Development and Police. And it echoes a similar theme from the Independent Experts Forum report in 2009. Now, some agencies have not been traditionally involved in the family court process, and some of you will know that when you've attended family group conferences. But the respective ministries of education and health have significant parts to play if we are to establish truly multidisciplinary approaches to these issues, in addition to the Ministry of Social Development and its service arm, Child, Youth and Family. We need to ensure we set deadlines and that they are met. In the family court, when we undertake our child offenders work, in particular, as the Select Committee said, we need to make sure that the rehabilitative plans are carried out, that there is an audit, and that we do what we said we would. And so, to conclude, The United Nations Convention on the Rights of the Child has provided a useful platform for the exploration into how we can value New Zealand children from the start. It's so important to reaffirm the fact that children do have inherent rights that must be protected and must be upheld, and the family court has its duty and its responsibility. This applies to all children, irrespective of whether they come to us through private or public law. Now, I've focused on public law cases, the care and protection ones, because I wonder whether the recent announced reforms go far enough in protecting children. Effective early intervention must be a priority of all who work in this area, and I hope that coordinated information sharing protocols, a specialist division of the family court, and stronger powers to compel agencies will go a long way. Now, I finish. At the same time as saying this, it's important to remember that all children are inherently vulnerable, all children. And children who are exposed to parental conflict in the private law disputes are also at risk. While these are wholly different to the kind of abuse, neglect, and drug and alcohol concerns that are seen in our public law side of our work, children who are subjected to ongoing parental warfare must also be protected and given a voice in proceedings. While today I have focused on children in need of care or protection, I want to end on a note of warning with regard to the proposed reforms for the family court. New Zealand has international obligations to ensure that all actions concerning children, all children, in relation to our children, the best interests of the child shall be a primary consideration. Ensuring that children are both heard and represented adequately is critical, because so often, and I finish on a very deliberate note, if you don't mind, so often when I talk to children, it's them who can frame the issues much better than their parents and who can give me the real issues and the real answers. Thank you.